Well, I have been asked to speak to you on Rule 39 of the Rules of Court. Now, I'm sure that the majority of you have heard about Rule 39. But Karine, I think, also wanted me, and as you can see from the title, an insider's view on the application of Rule 39. So she wanted some, well, not quite confidential, but information which normally would not be available to the general public. In fact, among the documents which have been circulated, there is a document which is available publicly, which is the fact sheet on the Rule 39. I believe you have it already in your documents. Yes, the fact sheet. I will not attempt to read that because, of course, it makes excruciatingly boring reading. So what I will do is to try and give you some other information about Rule 39. First of all, Rule 39 is an invention of the court. Let's make it quite clear. It's not, there's nothing in the Convention which refers to interim measures. The rules of court were adopted by the plenary, by the court itself, and the current version of the rules of court, of course, is the one in force. But previously, even the old court and the Commission had their own provision on interim measures. The main difference, I would say, between the original text and the current text is that, well, there are two differences. First of all, the original text used the word "and any interim measure, the adoption of which seems desirable." As you can see now, that wording is no longer in use. What the court says, what the rule says, is that the Chamber, or, where appropriate, the President of the section or a duty judge appointed pursuant to, there's another rule, at the request of the party or of any other person concerned. Now, in the majority of cases, it is the applicant or the would-be applicant who applies for an interim measure. But that is not necessarily the case. Indicate to the parties any interim measure which they consider should be adopted in the interests of the parties or of the proper conduct of the proceedings. So it's not only in the interest of the applicant, it can be also in the interests of the government itself, or on the proper conduct of the proceedings. Previously, the old text referred to, used the words, any interim measure, the adoption of which seems desirable. Another difference from the original version to the current version is that under the original version, the court would give always, with every interim measure adopted, would give notice to the President of the Committee of Ministers, which, as you know, is responsible for the execution of the judgments of the court. That is not the case nowadays. Paragraph 2 says, where it is considered appropriate, but only where it is considered appropriate, immediate notice of the measure adopted in a particular case may be given to the Committee of Ministers. Otherwise, the Committee of Ministers nowadays makes do with the statistics that are published. I'm not quite sure how often, certainly about every three months or 4 months, and that is how the Committee of Ministers is informed. And since I have been at the court, I've been at the court since September 2010, I do not recall any particular instance in which I was involved in granting an interim measure where I actually ordered the immediate notice of the measure to the Committee of Ministers. So this paragraph 2 is applied if at all, very, very sparingly. Now, how does Rule 39 work in practice? Because on paper, well, there you have Rule 39, you have the document which was circulated, which indicates what must, the note or the request for the application of an interim measure, what it must contain, and so on and so forth. When I came to the court in 2010, Rule 39 requests were determined at section level. So, if there was a Rule 39 request from someone who requested an interim measure against, let's say, the United Kingdom, at that time, in September 2010, the United Kingdom was part of Section 4, and the request would be dealt with by by the case lawyers in Section 4, and eventually decided by usually either the President or the Vice President of Section 4. Now this allowed for or gave rise to a lot of, I wouldn't say conflicting decisions, but certainly there was no uniformity. First of all, because there were many judges involved, many vice presidents, at least 5, and also because the case was being, the application for the Rule 39 was being processed in the particular section by the lawyer who happened to be duty lawyer at the particular point in time. About 2 years later, I think it must have been 2010, 11, 12 or 13, it was decided to centralize the Rule 39 requests. Nowadays, a Rule 39 request, which can be made, of course, independently of the application, and in the majority of cases nowadays, the Rule 39 requests precedes the actual application. These are processed, well, they are received by the section, but as soon as the case lawyer realizes that a Rule 39 request is involved, this request is sent to the Rule 39 unit. And there it is processed immediately. The first thing that the Rule 39 unit does is to see whether at least the request meets the minimum requirements for an application for an interim measure. If it doesn't meet the minimum requirements, it does not proceed further, it does not even go to the duty judge or to a judge at all, and the person applying is sent a letter. By the way, Rule 39 requests cannot be made by email. They have to be made either by mail or by facsimile, as you probably know. Emails are not taken into consideration at all. So the applicant is informed immediately that his Rule 39 request, generally the expression used is out of scope of Rule 39. But I am one of those few judges in the court who have an ingrained, I resist the use of out of scope, because if you look at the wording of Rule 39, there is technically nothing which is out of scope. By out of scope, the case lawyers generally mean that it is not linked to an Article 2, Article 3, possibly Article 8 request, or an infringement of Article 8. So that means that is, well, generally out of scope. We shall see in a moment in which instances the court has applied Rule 39. Yes, indeed, in the majority of cases, there have been cases where the applicant alleges serious damage, serious and irreparable damage to his health, the possibility of inhuman or degrading treatment, immediate danger to his life, but there have been others. There have been others, like cases, for instance, where the court has even applied Rule 39 in asking the applicant to do something. There's a case which I don't remember off by heart, but I've made a note somewhere here. I think it was an interstate, no, it was against a case against two countries where the applicant was on a hunger strike. And the court, in the interests of the proper conduct of the proceedings, actually asked the applicant to terminate, I think it was Ilascu, I don't know whether it's mentioned in the Ilascu and others, against Russia and Moldova. But anyway, the court asked the applicant to terminate, to stop the hunger strike. And in fact, the applicant agreed. Of course, why did presumably, I don't know the reason why did the court? Because, of course, if the applicant continued with the hunger strike, that may have necessitated the court actually rushing the case through and possibly, of course, upsetting the whole schedule and so on and so forth. So there you have an example of the proper conduct of the proceedings. On the other hand, if you take Lambert and others against France, you remember the case of Lambert, the individual where after the case had gone through the French system, including the Conseil d'État in Grand Chamber formation or whatever it's called, it was held that to withdraw artificial feeding, well, it's actually in enteral feeding, in other words, feeding through tubes and so on, feeding and hydration actually, of an individual who was almost totally paralyzed. The domestic authorities held that that would not be a violation of Article 2 or 3 of the applicant's rights. There the court allowed an interim measure ordering the French authorities not to stop. And obviously in that case, the application and the application for the Rule 39 for the interim measure was made together with the application. It was dealt with on one day in September, and by, if I remember correct, February of the following year, the case had already been decided by the Grand Chamber. The Chamber actually in that particular case did not decide the case but referred the issue immediately to the Grand Chamber. There was the opposite of what happened in Ilascu. I think it was Ilascu. Do you remember it off by heart? No, Ilascu and others, but anyway, it was against Russia and Moldova, if I remember correctly. Who may allow a Rule 39 request, an interim measure? Well, strangely enough, it would appear from the wording of Rule 39 that the only body that cannot issue a Rule 39 is the Grand Chamber. And probably the reason is that the Grand Chamber as such, because if you look at the wording, it's always the Chamber, the President of the section, or a duty judge, but there is absolutely no reference to the Grand Chamber. Whether that is deliberate or not, the point has never been raised. I do not recall any instance where the Grand Chamber was asked directly or indirectly to apply an interim measure. My interpretation would probably be that the Grand Chamber may, because what the Chamber can, multo magis, the Grand Chamber can do as well. Now, in what instances have Rule 39 measures been applied? Obviously, a Rule 39 measure involves a certain amount of using the imperative. You must do this or you must not do that. So it's obvious that when directed against a state, there must be some really serious reasons for interfering with state authority in asking a state to do or not to do something. And of course, in view of the subsidiary role of the court, it means that in practice, the court is very cautious in applying an interim measure. Of course, this does not include, for instance, interim measures which are applied ex officio, One instance of an interim measure which was applied ex officio very recently was against Malta, where a number of prisoners, not immigration detainees, but ordinary prisoners, all of them foreigners, had great difficulty in communicating with the central office of legal aid in Malta. There, the section president, applying Rule 39, requested the Maltese government to assure that there would be adequate communication between these prisoners and the Office of Legal Aid in Malta, because on paper, the office was there. On paper it was there, but in practice, the communication was virtually impossible between these prisoners and the Legal Aid Office. So that's another instance where the Rule 39 was applied, in this case by the section president. Which are the cases where Rule 39 requests have been, interim measures have been applied? Well, the most obvious, and yesterday one of the speakers referred to FG against Sweden, where there is a risk of persecution for political, ethnic or religious reasons. Or ME against Sweden, risk of ill treatment related to sexual orientation. In another case, also against Sweden, dating from July 2003, Ibrahim Lunguli against Sweden, where there was the risk of being subjected to genital mutilation if the applicant was sent back to her country. Again, the risk of social exclusion or the risk of sexual exploitation. I believe yesterday someone referred to M against the United Kingdom, 1st December 2009. Or the risk of being sentenced to death or life imprisonment if extradited. The reference one normally finds in the notes, including, I believe, the notes that have been distributed, is to the case of Öcalan against Turkey. But remember that a Rule 39 measure, in a very mollified, in a very soft way, was also applied in the famous Sering case against the United Kingdom, where Sering risked being extradited from the United Kingdom to the United States, where he faced the death penalty among, well, at the time, of course, the death penalty had not yet been abolished in Europe, but in the United States, he faced the death penalty. The United States government was unwilling to give the necessary assurance, and in fact, the court, in its interim, in its letter to the British government, spoke of the desirability of the applicant not being removed to the United States before the court had a chance to examine the whole thing. And in fact, as you know, the court found that a violation of Article 2, it was a violation, no, it was a violation of Article 3, if I remember correctly, because not because of the death penalty as such, because the death penalty was still legal in some countries in Europe, but because of the so-called death row phenomenon, which amounted to inhuman and degrading treatment. Nowadays, the letter that is sent to the government is much more imperative. You are requested not to do this, or you are requested to do this. So it's not a question, as it used to be in the past, of telling the government it would be desirable to do this or do that. It's more imperative. Apart from Articles 2 and 3 issues, even Article 6 has been the subject of some Rule 39 injunctions. But normally, if the applicant merely states that it is likely that he will not get a fair trial in the country in which he's going to be sent to, either by virtue of extradition or some other procedure, normally that fact in itself will not bring about an interim measure under Rule 39. However, if it transpires from the facts, and this is why even in the practice sheet, the information sheet which is issued to lawyers, it is made very clear how important it is for the application for a Rule 39 to be fully substantiated and not merely have vague references to documents here and there. In one particular case, which is, I'm sure, very familiar to you, especially to people coming from the United Kingdom, Othman Abu Qatada against the United Kingdom, where the court said, look here, if this person is going to be extradited to Jordan, where he is going to be tried, he risks being subjected to a flagrant denial of justice. Therefore, even Article 6, some people would say, but Article 6 is out of scope. No, it's not out of scope. Where there is the possibility of a flagrant denial of justice, even Article 6 would be applied. And you probably know why the court, and eventually, by the way, the court in its final decision did find that there would be a violation of Article 6, not of Article 2 or Article 3, but of Article 6, if the United Kingdom were to extradite Abu Qatada to Jordan without getting assurances from the Jordanian government. Abu Qatada was going to be tried by a military court, but even that was not a problem for the Strasbourg court. Abu Qatada was going to be tried where the main, if not the only evidence in that case had been obtained through the torture of a third party or third parties. So the question of the flagrant denial of justice was not because he was not going to be heard, but because the evidence that was going to be brought had been obtained through the torture of third persons. There are other instances where Rule 39 has been applied, and including, of course, Article 8. In Article 8 cases where there is, especially when children are concerned and children are going to be moved from one place to another, the typical case that is mentioned in connection with Article 8 is usually Neulinger and Schuruk against Switzerland, which is perhaps the worst case that one can refer to, because that was the case where Rule 39 should not have been imposed, because once Rule 39 was allowed and an interim measure there was allowed, unfortunately, the court, both in Chamber and Grand Chamber, did not deal with the case as a priority case. Nowadays, the position is, and Karine made it a point to show me some document which is, some new document which is available online, and she said, here, but it says that, these are the priority cases. That document, I'm not saying it's meant to confuse people, but as far as Rule 39 is concerned, it is inevitable, invariably, that as soon as an interim measure has been allowed, that priority is allowed as well. So the case is given priority treatment. If it is also a case involving removal to some other countries, and therefore the issues of Article 2 or Article 3 could come in, again, I would say not even the norm, but it's the standard rule. Well, it would be the norm, I suppose, but I've never seen any exceptions to this, that anonymity and confidentiality are also applied. Now, my intention was actually to go through a number of cases which you will not find on the and this is what the insider's view, I suppose, that Karine wanted from me. These are checklists, which over the last few months have been dealt with by the court. Therefore, the application for an interim measure, as I said, can be accompanied by or request for an interim measure, can be accompanied by also a formal application, but it can precede the application. And there are various ways in which this request for an interim measure can be disposed of. The request for the interim measure can be allowed, or the request for the interim measure can be refused. But the request for the interim measure can also be adjourned until further information is obtained from the respective government. This is a procedure which is often adopted, for instance, in respect of Russia, the Ukraine, in requests for interim measure where people who are being detained either in prison as a result of imprisonment or awaiting trial claim that they are not receiving proper medical treatment. And in both countries, it's true that there are problems with medical treatment. But normally, before the court, as it were, or the duty judge takes the plunge, in that case, the request is, we call it adjourned. A letter is sent to the government asking the government to give further information about how many times the individual has been examined, to produce the reports and so on and so forth. Those documents are then referred to the applicant or his lawyer for comments, and then the court, through the duty judge, can decide. So once the information arrives, the lawyer in the Rule 39 section processes the document and prepares what is called a checklist for the duty judge. Now, what is the purpose of this checklist? The purpose of this checklist is, well, I would say twofold, but perhaps even threefold. First of all, to avoid having the judge to go through the documents himself, and therefore it avoids a lot of work for the judge. But more importantly, of course, nowadays the lawyers in the Rule 39 section are experts in dealing with Rule 39 requests, and especially requests involving migrants, but not necessarily migrants, as I've just mentioned in the case of Ukraine and Russia. So the facts are processed, are analyzed, then normally there is a reference also to information about either that particular country or that particular institution. If it's a prison, it's probably the CPT, well, if it's a big prison at least, the CPT has already been to that particular place, and we would be able to know what the conditions really are like in that particular place. So the background to this application is given to the duty judge, and that's the nice thing about it, the non-judicial rapporteur, who is a senior lawyer in the Rule 39 section, then makes a proposal to the judge. He recommends to the judge, to the duty judge, whether the request for the Rule 39 should or should not be allowed. I have to say that in the majority of cases, given the extremely high standard and competence of our lawyers, and I'm saying this not cicero pro domo sua, but really because this is a fact, it's true, one tends to agree. However, there have been cases, and I have one or two cases here, which I will, if I have enough time, indicate where the duty judge did not agree. Before the checklist is sent to the duty judge, it is normally also sent, unless the national judge says, I do not want to see any checklist. There are some national judges who are not interested at all in being informed about the Rule 39 requests. Most judges have not said no, therefore they are informed. And the checklist is sent, and all this is done by email, of course, and that's why you see me having 2 or 3 mobiles all the time, because one of them is the Rule 39 mobile, which sends and receives all this information. So the checklist is sent to the national judge, and the national judge is asked whether he has any comments to make on the proposal being made by the non-judicial rapporteur. In some cases, in most cases, the national judge does not comment. There have been a few cases where the national judge has said, I do not agree that the Rule 39 request should be allowed in this case for this and this other reason, but ultimately the final decision rests with the duty judge. with this, of course, caveat that the duty judge, of course, takes into consideration the views of the national judge, but they can be overruled. Incidentally, because I forgot to mention this, one of the latest extensions, if I may call it an extension, because as I said, nothing is technically out of scope, where a Rule 39 interim measure was applied, was in connection with an alleged violation of Article 10, freedom of expression. This was in a Georgian case, which is still pending. It's called Rustavi 2 against Georgia, which involved the transfer or the imminent transfer of a radio station which, from all accounts, by all accounts, is the only independent radio station in the country, would be transferred after the decision of the Supreme Court from its particular owners to a particular person who, according to information available, will be dismantling the whole system, sending the journalists away. This is a radio and television station, by the way. And therefore, the issue raised by the applicant is the question of Article 10. It had never been applied to Article 10 cases. In this particular case, a couple of months ago, I think it was, the duty judge allowed the request, but to make assurance double assure, the request was sent within, I think, 3 working days, also to a full chamber, to confirm or otherwise the application of the interim measure. And the full chamber, in that particular case, unanimously approved of the decision of the duty judge. When you have an interim measure under Rule 39, this does not guarantee that, of course, there is going to be a decision for a violation. The classic example is Lambert and others. The court applied Rule 39, but the court finally, the Grand Chamber, decided that there would not be any violation of Article 2 or 3 if the artificial feeding and hydration were to be discontinued. Let me very briefly, I had 10 cases here. And I was going to read the proposals, how the proposals are couched by the. Of course, I will not mention either names, dates, but only, of course, against which country and basically the facts. But I can't go through them all, but I will mention a few of them at least. Let's take, for instance, a case against Switzerland. This was a lady who, having traveled quite, I would say, quite in an open way from China all the way to Switzerland, landed in Switzerland and claimed asylum. Why? Because she claimed to be a member of a religious group known as of the Church of Almighty God, which is a Christian church, a sect, but is one of the prohibited sects in China. So you see, it's not only France that has some problems with sects, but even China as well. And after the examination of the case, the non-judicial rapporteur proposed to refuse the request for interim measures. And the proposal was couched in these terms. The general principles which are of special importance in the present case are laid down in JK and others against Sweden, about which we heard yesterday. Applying the principles to the present case, it has to be noted that the domestic court did not question the applicant's membership of Church of Almighty God, but found that the applicant, due to evasive and contradictory statements, failed to convincingly show that she had been ill-treated in the past and had been known to the Chinese authorities as an active member of this religious group. As she had been able to leave China without problems, there was no problem, it's true, nothing indicated that she faced a real risk of ill treatment upon her return, because of course the Swiss authorities had refused the asylum request at various levels, and therefore it was proposed to dismiss the case. As it is not the court's task to substitute its own assessment of the facts for that of the domestic courts, and as a general rule it is for those courts to assess the evidence before them, again there is a reference to JK and others against Sweden, it can be noted that the domestic court gave relevant and sufficiently detailed reasons why it was of the opinion that the applicant's statements were not credible with regard to her situation before she fled China. And then it was added, as regards the future real risk of the applicant upon her return, which in the present case is not linked to a past ill treatment, the domestic court's assessment that, having left China without any problems and apparently not having been on any wanted list or searched for by a warrant, the applicant failed to indicate any reason why she should be subject to ill treatment upon her return, cannot be found unreasonable. In other words, the conclusions of the domestic courts. It is true that the domestic court did neither take into account the well-known situation of the members of the religious group as indicated above, even though the applicant had lived in a region where the Church of Almighty God had been founded and where it is centered. Nor did it give any reasons for its assumption that only active members had been persecuted by the authorities. This was the general drift of the domestic authorities. She was not an active member of this church. Only active members have been persecuted, and therefore she doesn't risk any persecution. And therefore, taking into account the views of the national authorities and so on and so forth, the proposal was to refuse the Rule 39. The duty judge, who will remain anonymous, of course, refused this advice. While it is true that the general rule is that it is not the court's task to substitute its own assessment of the facts for those of the domestic courts, this does not necessarily mean, said the duty judge, that the court may not, upon the evidence submitted to it in the course of the proceedings before it, in the course of the proceedings which still had to start, because in this case there was only the request at this particular stage for the Rule 39, because she was going to be deported within a couple of days back to China. The case in hand, said the duty judge, involves the clear possibility of inhuman or degrading treatment at the hands of the Chinese authorities. It is not a case of conversion, whether surplus or otherwise, as was the case with the Swedish case. So the cases mentioned, and there was a checklist, in a particular checklist, are not of much help, because what the case lawyers were looking at were cases of conversion surplus. Dubious as the cult or sect in question is regarding its religious belief or beliefs, there is no doubt from the reliable evidence generally available that members of this sect or cult have been targeted for especially harsh treatment by the authorities in China. The underlying basis being not so much a question of belief or religion, but one of political opposition. So it was not a question so much of the religious belief, but this cult or sect is seen as a political opponent. The administrative court, concluded the opinion of the duty judge, the administrative court in Switzerland, did not exclude that the applicant was a member of this sect. Its dismissal of the asylum application is based on the degree of her active membership. However, my reading, said the duty judge, of the available material is that even ordinary members of the sect are subject to treatment which can reach the Article 3 threshold. Therefore, he said, at this stage, or was it she, I don't know, because it's the duty judge, at this stage of the proceedings, and notwithstanding the findings of the Swiss authorities to date, the duty judge was holding that her case is he cannot hold that her case is manifestly ill-founded. A chamber may well reach the conclusion that there will be no violation even that the application is manifestly ill-founded. But the duty judge said, I cannot. For these reasons, Rule 39 was granted to prevent her removal to China before this court has had the possibility, the Strasbourg court, has had the possibility of examining properly her case. The application is to be communicated immediately. That's one other option that the duty judge can do, is to order immediate communication to the respondent government, and of course anonymity and priority are also granted. So there you have one instance where the Rule 39, the proposal was that the Rule 39 request for not having this person removed to China, but the duty judge disagreed. Another instance, and I have to stop here, I mean, I had 10 cases. Of course, I'm an incorrigible optimist when it comes to these things. Another case which perhaps I could indicate is a case, let me just check quickly. I had yes, an expulsion of a Nigerian woman to Italy. The proposal in this particular case also was, and in fact, to be fair, the non-judicial rapporteur said this is a borderline case. The applicant is an adult Nigerian woman who came to Austria alone. She allegedly left her 6-year-old twins in Nigeria when she fled the country and was accommodated in a camp for 3 days in Italy before moving on to Austria. She did not complain about anything in particular in respect of her treatment and accommodation in Italy, but only submitted that she did not want to stay there, citing various country reports and case law from different countries. However, the very recent country reports cited above indicate that Dublin III returnees who left the accommodation can apply for readmission, and that a particularly vulnerable will be taken into account. Her submission concerning the accommodation in Italy is thus unsubstantiated. The applicant's physical health does not raise concerns under Article 3, because she had some particular physical health condition. However, she appears to be in a vulnerable situation due to psychological problems. Both the official medical report issued by a medical official and the psychological report obtained by the applicant indicate that she probably suffers from post-traumatic stress disorder and depression, and that her removal would worsen her psychological state. This was, of course, a removal from one country to Italy. In sum, the applicant's situation does not appear to be comparable to the cases in which an interim measure was granted in respect of removal to Italy recently, and there is a reference to the cases. Well, the duty judge, again, did not agree with this, having examined everything and probably even sought other information, and the duty judge said, I beg to differ in this case. The applicant risks not only not receiving appropriate medical care consonant with her condition, but having already been in Italy, and therefore having left and trying to return now, she risks ending up in the streets, that is, not being accommodated in a reception center. In the circumstances of the case, Rule 39 is temporarily granted, but only temporarily granted, and the respondent government is to be asked to indicate within 14 days what steps have been taken in conjunction with the Italian authorities to ensure, because the respondent state is, of course, in this particular case, Austria, not Switzerland, Austria. And the respondent state is to be asked to indicate within 14 days what steps have been taken in conjunction with the Italian authorities to ensure that upon transfer she will be accommodated in a reception center and given medical care consonant with her particular needs. The case will be again reviewed upon receipt of the replies or the information. Again, this is a possibility, granting a temporary interim measure and then reviewing it at a later stage. There are other permutations and combinations, but the bottom line is this. As you can see from the wording of Rule 39, it is a very flexible tool. The important thing is, of course, that when it is applied by the court, it is applied judiciously and only in those cases which really merit an interim measure. Interfering, well, finding a violation against the state is already something quite serious. Finding a violation of Article 2, of Article 3, of Article 6, any violation. The court has also held that if a state does not abide by the interim measure, that in itself is a violation of Article 34, interfering with the right of individual petition, with the proper right of individual petition. So it is very important that Rule 39 is only applied in those cases where, on the face of it, merit its application. And as I said, whenever Rule 39 is applied nowadays, it is invariably given priority, anonymity, and confidentiality, and it is fast-tracked so that if the Rule 39 has to be removed, it will be removed as soon as possible. That is, well, that's not what I had to say. I had lots more to say, but I don't have time, and I thank you for your patience. Thank you very much indeed.